Hi everyone, and welcome to this vlog on subject access requests. I'm Claire Hall. I'm a senior associate in the data protection team at BWV, and I'm joined today by my colleague Bronwen Jones, who is an associate in the team.
So today's vlog is about subject access requests, what is a subject access request, and just some hints and tips for how to handle them. So to start things off, what is a subject access request? It's a request that an individual can make for their personal data to an organisation that holds their personal data. It doesn't necessarily have to be in writing, so they don't need to write you a letter or an email. A request can be made in lots of different ways. So it could be made via a social media channel, or it could be made in person or over the telephone as well. So it's important to keep an eye out for requests to make sure that you can deal with them appropriately.
So one of the key points to consider when you receive a request is it genuine? Now, it's unusual for somebody to make a fraudulent request, but because information security is such a high risk issue around data protection compliance, it's always worth thinking, do we need to ask the requester for any ID or any kind of verification that they're making a subject access request? So it's sometimes quite straightforward because maybe a current employee makes a subject access request and you know them and they make it from their work email account. So it's obviously pretty much from them. However, if you receive a request from an unknown email address, for example, then it's often better to be safe than sorry and ask the requester for ID. However, you shouldn't ask the requester for more information than you reasonably need to verify their identity, because you shouldn't be putting unnecessary blocks in the way of progressing their subject access request.
Another point to consider is whether or not you need to enter into a dialogue with the requester in order to clarify what they're looking for. So sometimes a request might be very broad and you might hold quite a lot of information about the individual. For example, if you have a member of staff who's worked with you for a number of years, they could have generated quite a lot of personal data. If they're asking for everything that you hold, you might want to think about going back to ask them if they can be a bit more specific. And you are permitted to go back as long as you do so within a reasonable time to ask them to provide perhaps some more information to assist you in locating what they're seeking.
So one of the questions we often get asked is, how long do we have to respond to the subject access requests? Because they're generally quite time consuming. So the general rule is that you have one calendar month, and that calendar month starts on the day you receive the request. However, unfortunately, it's a little bit more complicated than that. So, for example, let's say you go back and you ask the requester for some ID. Well, then in that case, the request doesn't start until you've received the ID. If you go back and ask the requester for clarification, as Bronwen has just described, then the clock pauses whilst you wait for their response. You can have up to an additional 2 months where a request is complex or where you receive a number of requests, but you have to let the requester know about that extension within the first calendar month. I should also say that if the deadline falls on a weekend or a bank holiday, then you have until the next working day. So I'll use today as an example. Today is the 26th of August, but the 26th of September, so one calendar month from today, is a Sunday. So that would mean you have until Monday, the 27th of September. We're now going to do a myth-busting section, and I'll start by busting some myths that Bronwen will kindly let me know about.
Myth number 1 for you, Claire. Subject access requests only apply to information that's held electronically.
So that's not entirely correct. So personal data can also be held in a paper filing system. However, the definition of filing system can be quite complex. So our advice is that if you think you might hold some of the requester's personal data not electronically, it's always worth seeking our advice on that point because it can be quite a complicated area. In addition, if your organisation is a public authority, i.e. you are covered by the Freedom of Information Act, then the scope of paper filing system is even wider and more information might actually be caught.
Okay, and myth number 2, the requester must provide a reason for their request.
So requesters don't need to provide a reason for their request. However, it can be helpful sometimes to understand why somebody is requesting their personal data, because that can help you locate the personal data that they're seeking. But you certainly cannot require them to give you a reason for their request.
Great. And the request has to be made in writing?
So this is an area where people get a little bit confused, because the old law, so the Data Protection Act in 1998, did say requests had to be in writing. But when the GDPR came in 2018, it was silent on this point. So requests can be made orally as well as in writing. So somebody can make a request over the phone or in person. So there's no requirement for them to put their request in writing.
Okay. And then myth number 4, if we hold information received from a third party, then we don't need to provide that information.
So any personal data for which your organization is controller under data protection law is potentially disclosable under the subject access request, subject to exemptions, which we'll touch on in a moment. So the question is your organization controller? Now, controllers are the organization or the legal entity that is responsible for deciding how and why personal data is used. So just because, for example, you've received an email from a third party, if that email contains the requested personal data, it is potentially disclosable, subject to applying an exemption. Right, I think I'm now going to do some myths that Bronwen's going to bust. So the first one is only factual information about someone is disclosable.
So this isn't quite right. Personal data can include opinions as well as factual information. So that's worth bearing in mind before you commit anything to writing, and in particular, making your staff aware of it as well. So it's best practice to train your staff to keep comments professional, and to only put in writing what they would be happy for the other individual to see. There isn't an exemption available under the Data Protection Act for comments which are a bit embarrassing or phrased a bit candidly.
Excellent. So the second one is the requester has asked for everything we hold, and it is going to take us a really long time to find it all. So can we just refuse to comply with the request?
So unfortunately, no, there's no mechanism available to just refuse to comply with a request because it's going to take you a really long time. The obligation is to carry out reasonable and proportionate searches. So although you can't refuse the request entirely, what you can do is limit your search criteria, and hopefully the requester can help you by providing some information in order for you to do that. So perhaps limiting it to certain date ranges or mailboxes of individuals, based on the information that you have available about the context of the request. There's also the option for if it's a manifestly unfounded or manifestly excessive request, then you could refuse to respond. But it's important to note that the threshold for this is really very high. So if you were concerned about that, it would be best to come and speak to us about it, and we can let you know whether or not we think that's available to you.
And then the next one is information which is also about someone else is definitely not disclosable.
So again, unfortunately, that's not quite right. Where you have information about the requester and another individual, this is what's known as mixed personal data. So in certain circumstances, it might be possible to withhold that information, but it also might be that you do need to disclose it, and that's very dependent on the circumstances of each case. So it's worth assessing on a case-by-case basis whether or not an exemption applies there, or whether you need to disclose information about another individual.
And then the last one is we have to provide copies of documents redacted if necessary.
So the entitlement is to a copy of the personal data as opposed to the original document that the data is contained in. So you don't necessarily have to provide redacted copies of documents. It's possible to take the personal data. So for example, if it was a comment from an email, you could just take that comment out of the email and put it into a separate document and disclose it in that way. And that would be a perfectly reasonable way of responding to the request if redacting wouldn't be appropriate.
Excellent. Thanks, Bronwen. So Bronwen and I regularly advise on subject access requests. So we know they can be complex to deal with, and they can also be quite time consuming. So if you ever need any assistance with them, do let one of us know and we'd be delighted to help you. Thank you for your time today.